Good evening, everyone, and it's always a pleasure when you tie up of Beyond Law CLC with legal elites. And under the aegis of Adi Lakshmi Logamurthy, we have taken sessions which have different fascinating aspects. And Mrs. Adi Lakshmi was the connecting point for connecting us with Shangar Murli, who is an important resource person, not only for legal elites, but also when we have been collaborating on the legal knowledge sharing. And as we know that Mr. Shangar Murli has been taking different perspectives of law, which are not only relevant for the purposes of a common man, but also as we find that the legal journey and the legal minds also get eliminated once these right sparks have been ignited by persons like resource person of Shangar Murli. And today there's a fascinating topic of what we say setting aside of the fraudulent sale deed without the resorting to the civil court. This aspect looks quite fascinating, and during this legal journey sharing, it will be always quite illuminating as to how it can be done. And it will also not only help the persons like lawyers to understand, but also common man as to how you can come out of the legal trappings of the civil court. And I will not take much time. I will request Adi Lakshmi ma'am to share the insights regarding Mr. Murli as well as knowledge sharing, and then we will request Mr. Murli to share his knowledge. Over to you, Adi Lakshmi ma'am.
Thank you so much, my dear brother Vikas. It's so nice for Legal Allied to get connected once again after a long time with Beyond Law CLC. And today, Shangar Murli sir is very well known, almost all parts of India, for his legal knowledge and his wish to share his knowledge free of cost. Sir doesn't take even a single pie for sharing, whatever may be the platform, whether it's online or offline. He shares his legal knowledge. That he's an exponent in civil law, but he tries his hand sometimes on the criminal jurisprudence as well. Today, he has such a great fan following, and he's a godfather for all the young lawyers and young law students down south. Today, he has been traveling to north, and in fact, he had recently had an opportunity to meet Vikas, and he met and was very happy. COVID-19 had done so much of harm, but for the legal fraternity, it has done lots and lots of good. And one such goodness is connecting us towards every one of us. Networking has gone in a larger way, and also acquiring the legal knowledge on platforms like this, and also the creations of YouTubes where we get to know the sessions, even though we missed due to our busy schedule. And today, one of the pertinent topic, which, as Vikas told, Sir is going to deliberate with us. And I wish every one of you, we are going to have a very good session. And on my personal behalf, I wish my elder brother, our godfather, patron of Legal Allied, our own respected and beloved Shangar Murli sir, thank you so much for joining in on this platform today. On behalf of every one of you, on behalf of Beyond Law CLC, and on behalf of Legal Allied team, I extend a very warm welcome to our most respected and beloved faculty of the day, Mr. Shangar Murli sir. Welcome, sir, to this platform.
Thank you. Thank you, madam. Thank you to Mr. Thank you, Vikas ji and Adi Lakshmi, madam. Normally, I used to take classes for those who are all cracking the judicial exams, students and mainly the lawyers. But this is the first time I am going to deliver a judgment on the topic which is burning topic, whether a fraudulent sale deed can be set aside without resorting to the civil court. The law on this subject is well settled. If I want to set aside any document which is against me, if the document is allowed to be in existence, and if it causes severe embarrassment to me, and the document is void on the face of the record, then my remedy is to approach the competent civil court to file a suit for declaration that the document registered is illegal, null and void, and not binding on me. This is section 31 of the Specific Relief Act. So, all of you know and will quite concur with me. Filing a civil suit and get a remedy therefrom is a cumbersome process. It's a cumbersome process. Of course, to vindicate our legitimate right remedy, we can approach the civil court. Suppose you are the owner of the property. You have not at all sold the property in favor of any third parties. You are in possession and enjoyment of the property. You are holding the original sale deed and all the prior title deeds with you. But in one ill-fated day, some person, an impostor, by making false personation, executed a sale deed in favor of a third party in respect of your property. You are not aware of the same. There are chances of impersonation. Lot and lot of cases are pending on this subject before the various courts in India. I was wondered why the innocent purchaser shall be punished. Is it not amount to causing insult to him? He didn't anything wrong. Some person fraudulently executed a registered sale deed. In order to set aside the same, then why should I approach the civil court? Why should I engage an advocate, pay him a fees, and to pay the court fees to set aside the document? And I have to all along wait for the result of the case. Getting a degree from civil court, it may take minimum 5 to 10 years. Thereafter appeal, second appeal, SLP. For no fault on the part of the innocent owner, he is compelled to, he is dragged into the arena of the dispute. So is there any law? Then how to set it right? How to prevent this menace? So I have conducted a case. Before the High Court of Judicature, Madras bench, and obtained an order. Because my client's property was sold by an impostor. My client was in America, taking advantage of his absence in India. His adjacent owner, in conspiracy with some third party, present to service a registered power of attorney, as if my client has executed a power of attorney in his favor to sell the property to my adjacent owner. On the basis of the fraudulent power of attorney, my property was sold in favor of my adjacent owner. Then he occupied my place. On my client's return from America, he was shocked and amazed. And he made a roving inquiry, and to his dismay, he came to know that his property was illegally sold. Then he has consulted many advocates. Invariably, all of them said the only proper remedy is to file a suit to set aside the sale deed by paying court fees on the amount mentioned in the sale deed and get recovery of possession. Then he inquired and finally he came to me. I have perused all the records. In the power of attorney, the photograph of the impostor is affixed. It is not my client. And his identity card, some voter identity is mentioned. Then we obtained information under the Right to Information Act, and the information was furnished to that effect. The voter ID issued to my so-called power agent is a fake one. He is not at all in existence. He is only a fictitious person. Then we filed an application before the registrar to set aside the fraudulent sale deed. And he conducted a roving inquiry, obtained all the documents. We have produced the original sale deed, revenue records, everything. And they are not in a position to produce the document. Here, I would like to tell one thing. Whenever any document is, sale deed is presented for registration, it must, the recital must contain warranty of title. Suppose the sale deed recites like this: I, the owner, hereby convey the property which is all along under my possession, and I have been issued patta. I am selling this property in your favor. This is not a warranty of title. The title deed must state how the vendor acquired title to the property. What are all the prior title documents? How the property was dealt with by the vendor, whether his name has been muted in the revenue records. So if it contains, then it is a clear case of warranty of title. In the fraudulent sale deed, it has been alleged the original sale deed is missing. They have obtained a certificate from the concerned police, that non-traceable certificate. Based on that, my property was sold illegally. Then the district registrar conducted an inquiry and he came to a conclusion that it is a fraudulent registration. But he said, it is not within my domain to decide the title to the property or to set aside the fraudulent sale deed, because the only proper remedy is to approach the civil court. That is the order passed by the registrar. Then straight away I have filed a writ petition. I don't want to approach the civil court because I know, being a civil lawyer, it will take years together. Then finally the matter was listed for final hearing. Based on the Satyapal Anand versus State of Madhya Pradesh, the law as of now, once a document is registered fraudulently, the only remedy open to the affected party is to approach the civil court to get his remedy. Then I have narrated the power of the registrar under section 34 of the Registration Act and Rule 55 and Rule 162 of the Registration Act. What is the power of the registrar? Whether the registrar has got power to inquire before registering the document. Then I quote section 34 and Rule 55. Though it is not within the domain of the registrar to decide the title to the property, whether the executor has got absolute right to convey the property, yet he has to satisfy himself that the person appearing before him is the vendor, is the executed, by verifying his Aadhaar card, ID, and other things. Then only subject to satisfaction that the person appearing before him is the person proposes to be, then the registrar may register the document. If the document is registered casually, without examining the person appearing before him, then in the eye of law, it is not at all an act of registration. Apart from that, Rule 118 of the registration rules says, if it is brought to the knowledge of the registering authority that a particular document is fraudulently registered, then he can make an entry in the encumbrance certificate, namely Book 1, that the document is fraudulently registered. There cannot be any further hearing. That is enough. So I have requested the Honorable Court, let the registrar make an entry in the Book 1 that is the encumbrance certificate maintained by him, that the so-called fraudulent registration is fraudulently registered. It does not convey any title in favor of the purchaser, and there cannot be any further alienation. Apart from that, section 82 deals with penalty for false personation. 7 years imprisonment is contemplated. That has been ordered. So, the very object of choosing this topic is for the benefit of the legal fraternity and especially to all the civil lawyers. This is a very good, interesting subject. I'm going to cover the Registration Act and the rules framed thereunder, Specific Relief Act, particularly Section 31, Transfer of Property Act, particularly Section 55, and various decisions of our Honorable High Court and Supreme Court. My humble submission is, you must know the distinction between void and voidable document. A document which is void on the face of the record, it does not declare to be void by a competent civil court, because the document by its nature is void. Suppose any misrepresentation made as to the contents of the document, you may avail loan from your friend. You may be an illiterate person. Instead of executing a mortgage deed, your friend may obtain sale deed. Then it is voidable at your option. Then necessarily you have to file a suit to set aside the sale deed. That my intention is not to execute sale deed. It is only a mortgage deed. Suppose you are having undivided share in the property. Your brother sold not only his share, but also including your share he has sold. Naturally, you have to file a suit to set aside the sale deed so far as your share is concerned. Because your brother may take, there is a oral partition, I have relinquished my share. So the disputed question of facts, and the contractual duties and obligation of the parties is not well within the ambit of Article 226 of the Constitution of India. But in the case of fraudulent sale deed, a duty is cast upon the registering officer to verify whether the executant is the real owner or not. If he failed in his duty, then we can approach the High Court under Article 226 of the Constitution of India. Then let us see what is a sale deed. Sale is defined under Section 54 of the Transfer of Property Act. The sale consideration may be past, present, or in future. Normally, under the Contract Act, agreement without consideration is void. But here there is a promise. Even without receiving the sale consideration, one can execute a sale deed acting on the promise to pay the sale consideration in future. So, sale deed is a document which transfers ownership. The transfer is complete and effective upon the completion of registration of the sale. After executing the sale deed, the vendor is divesting his title to the property and the ownership passes to the purchaser. Assuming for a moment, I have executed a sale deed in favor of some X. He has promised to pay he has paid certain amount as balance amount and promised to pay the balance sale price in future. But thereafter, he failed to pay the balance sale consideration. Then what is my remedy? Can I impeach the sale deed on the ground that I have not received the entire sale consideration? I cannot. Because under law, I am an unpaid vendor. My legal rights and remedy is to file a suit for the recovery of the balance purchase money under Section 55, subclass 4, small b of the Transfer of Property Act. And after obtaining a degree, a charge will be created, a statutory charge will be created, on the property conveyed till the balance sale price is paid in full. This is the well settled position of law so far as unpaid vendor, right of unpaid vendor is concerned. Suppose sale deed was executed without consideration or with part consideration. The possession is retained by the vendor himself. The original document is retained by the vendor himself. The intention of the vendor is to pass title only on the payment of the entire sale price. Then title will not pass. Title will not pass. So, registration prima facie is the proof of intention to transfer of the property, but not the proof of operative transfer. This has been held in Kaliyaperumal versus Rajagopal, 2009 4 SEC, page 193. 2009 4 SEC, page 193. This is the very landmark judgment. It gives right on the unpaid vendor to impeach the sale deed on the ground that it is not his intention to pass the ownership on the date of execution of the sale deed, because the purchaser has to pay the balance sale price. Unless the balance sale price is paid, it is not my intention to convey the property, to pass the ownership. Now, I may illustrate in this way. I have paid the entire sale consideration. The sale deed receipts, entire sale consideration is paid, and I have executed a registered sale deed in favor of X. There is not, my sale deed contains a recital. After receiving the entire payment, I have executed sale deed. Can I unilaterally cancel the sale deed already registered in favor of X? I have presented the document unilaterally to cancel the document already executed in favor of X. The registrar verified the same and registered. Then what is the remedy open to the purchaser X? There are two questions. Number one, whether the vendor who has received the entire sale consideration without the knowledge and consent of the purchaser can present the document for registration, cancelling the document, cancelling the sale deed already effected. If such a cancellation of registered sale deed is registered, then what is the remedy available to the purchaser who has paid the entire purchase money? Can we compel him to go to civil court to file a suit to set aside that the cancellation of the registered sale deed is illegal, null and void? What is the remedy? The first one, so far as vendor I am concerned, under law, I have no authority because sale deed is a bilateral document. It is not a unilateral document as in the case of will or settlement. There is a corresponding reciprocal promises, obligations. I have received, my purchaser has to pay sale consideration, I have to execute sale deed. Once I have received the entire sale price, I have to execute the sale deed. It's a bilateral document. Having received the entire sale consideration, on my own, I cannot unilaterally cancel the sale deed already effected by me. Number one. So the document is what? It's a fraud. It not only is fraud on me, it's a fraud on the statute. But rightly or wrongly, document is registered. Cancellation of registered document is registered. Then the purchaser filed a writ petition under Article 226 for the cancellation of the sale deed. stating that I have paid the entire sale price. I was inducted into possession of the property. My name has also been mutated, but illegally, my vendor, without my knowledge, unilaterally cancelled my sale deed that has been registered. It is a sale deed on the basis of the record. Is the cancellation of the sale deed is null and void, not binding on me. Cancel it. This matter came before the full bench of the Honorable Andhra Pradesh. In Yanala Malleswari and others versus Anantula Sayama and others. This is a full bench decision. 2007 1 CTC page 97. It has been held by majority that the registrar has got power to receive, present to receive the document cancellation of the registered sale deed. There is no flaw in it. He did his duty. Registration Act empowers him to receive the document. It may be a cancellation of the registered sale deed. But the dissenting view is very apt. It has been held that registrar has no power to cancel registration of document already registered, since the registrar becomes punctus officio once the document is registered. If a person sold away the property belonging to others, then it will be a fraud on statute. If the original owner is asked to go to civil court and get the subsequent sale deed cancelled and seek declaration, would be adding insult to the injury to the owner. So that is a dissenting view. Later, in Satyapal Anand versus State of Madhya Pradesh, 2015, 15 SEC 263, 2015, 15 SEC 263. The Supreme Court gave a conflicting decision by Honorable Justice Deepak Mishra and Honorable Justice Mr. Sadananda Gowda. Justice Mishra said, the registrar has got power to register the cancellation of the registration, cancellation of the registered sale deed, because the Registration Act empowers him. But Honorable Justice Sadananda Gowda said, no, it's a fraud under statute. Once a document is already registered, cancelling the same unilaterally is fraud, it is a nullity. Then the matter referred to full bench, 3 bench. Again, it has been considered. And it is reported in 2016, 10 SEC, page 767. 2016, 10 SEC, page 767. The Honorable Justice Deepak Mishra judgment was affirmed. So the majority view is registrar has got power to cancel the registered sale deed already effected. The only remedy open to the party affected is to approach the competent civil court and get his redress. Is it not shocking? Please read the judgment in full. That is the case. The petitioner who has filed the writ petition was allotted a plot by a Punjabi cooperative society. In the bylaw of the society, if the plot already allotted and the sale deed was executed in respect of the same, if the allottee failed to construct a building within 2 years, then automatically the plot will be resumed by the secretary of the society and it will be re-allotted in favor of other person. The writ petitioner has not constructed the building within the stipulated time frame. So therefore, that prompted the secretary, straight away he went to the registrar, presented a document for cancellation of the sale deed. That is, it is known as extinguishment deed. That was registered. That was registered. Then he filed the writ petition. Then the writ court said, no, this is only a disputed question of facts. It cannot be gone into under Article 226 of Constitution of India. We are not here to decide the private parties' independent rights. Go and approach the civil court. So this Satyapal judgment case is only on the footing the bylaw of the society empowers the secretary of the society to cancel and present a document for registration, cancelling the sale deed already effective. There is no rules in the Madhya Pradesh registration rules preventing the registrar from registering a cancellation of registered sale. After the full bench decision passed by the Andhra Pradesh Yanala Malleswari case, rule was amended. Thereby, registrar is prevented from registering cancellation of the registered sale deed. If both the purchaser and the vendor filed a document for cancellation of sale deed, then it can be registered. Unilaterally, it cannot be registered. Similarly, our Tamil Nadu government has also passed a circular by the Inspector General of Registration. The Tamil Nadu government amended Section 34A of the Registration Act, whereby the purchaser is required to sign the sale. So, based on this Satyapal judgment decision, invariably all the high courts in India passes an order that whether it may be a fraudulent registration, go to civil court. Forgetting for a moment, this is the decision of the Satyapal case is on different footings. Then what about Section 55(4) subclass B of the Transfer of Property Act? It confers a right on the unpaid vendor to sue for the balance sale price. He cannot impeach the sale deed. He cannot file a suit to set aside the sale deed. Set aside the sale deed. Suppose the aggrieved person owner, as per the order of the High Court or Supreme Court, I have to file a suit to set aside the sale. Normally, normally the practicing civil lawyer, what would we do? We need not file a suit to set aside a sale deed because we have to pay the court fees on the market value of the property on the date of filing of the suit. It may be heavy. In order to avoid the payment of court fees, we used to file a suit for declaration that the registered cancellation of sale deed is illegal, null and void, not binding on me. We will file under Section 25D and tentatively value the subject matter of the same, and we will pay the minimum court fee. So, someone issued the defendant appear. He will not allow us to proceed the case. What they will do, the defendant, he will file an application to reject the plight on the ground that the payment subject matter of the suit was improperly valued and the insufficient court fee is paid. So reject the plight. Please keep in mind, when you are not a party to the document, when the document is fraud on the face of the record, when the document is not binding on you, you need not pay court fee on the market value of the suit property or on the amount mentioned in the sale. You just simply ignore the sale. You can very well file a suit for declaration to declare that the registered cancellation of sale deed is illegal, null and void, and not binding on you. You are fully competent to value the subject matter tentatively and pay the court fees in accordance with your tentative valuation. he will file this application to reject the plight. Then we will argue and file, produce certain authorities. Then the application will be dismissed. Again, he will not allow you to continue further. He will file as against the order rejecting his application. He will file CRP, then SLP. Then he will file another application to compare the signature. Our case is that it is not my signature, it is a fraudulent signature. Then he will file, no. He came and executed the document only for the purpose of filing the case. He has alleged that it is not his signature. Compare the signature. It must be compared by the expert. Then we are quite sure that it is not our signature. Then we will say, yes, I will subscribe my signature, that it be compared. Then he will file another application. If the signature is not his contemporaneous signature, then this process will go for another 2 to 3 years. Even that application is dismissed, or the expert opinion is produced that it is not our signature, he will not be satisfied. He will file another application for appointment of advocate commissioner, stating that after the sale in his favor, he has developed the property, made some development that has to be, the physical feature has to be taken note of. So one after another, by filing interlocutory application, your adversary will not allow you to get a degree in your favor. So it is a cumbersome process. Why the innocent purchaser must be punished? So this is the right time. Our Tamil Nadu government has amended, inserted section 22B of the Registration Act, empowering the registrar to cancel the document which are fraudulent. Normally, the disputed question of facts cannot be decided. Registrar is not a quasi-judicial officer. But in some cases, there are fraudulent registration. So now the government of Tamil Nadu gave power to the registering authority to cancel the fraudulent registration. Now, earlier, the High Court of Madras Division Bench in E.R. Kalaivan versus the Inspector General of Registration, 2010 Madras page, AR 2010, page 18. It has been held that the registering authority has no power to register cancellation of registration, cancellation of the sale deed filed unilaterally by the vendor. So, as I said earlier, a document which is void, it need not be declared as void. We can simply ignore. This has been held in Prem Singh and others versus Birbal and others, 2006, 5 SEC, page 353. Then what is the object of the Registration Act? The full bench of the Honorable Madras High Court, in the case Latif Estate Lion India Limited versus Mrs. Khadija Amal, reported in 2011 to MLJ 569, has held the object of registering a document is to give public notice to the public at large that the document has been executed, to prevent fraud and forgery, and to secure a reliable and complete amount of all transactions affecting the title to the property. The object of the registration is not merely to collect revenue. It becomes part of public policy. It becomes part of public policy. Document which is against public morality and public policy is void. Section 23 of the Contract Act says, a fraudulent deed is void. A fraudulent deed is void. So I am confining the right of the innocent owner of the property to file a writ petition under Article 226 of Constitution of India for the cancellation of the fraudulent sale. Or he may approach the concerned sub-registrar registering authority with a request that by producing all the documents that it is fraudulent, that the document is fraudulently registered, make an entry in the encumbrance certificate that the document is fraudulently registered and prevent further alienation in future. So these two options I will answer Mr. Ashok after this session is completed. Now two options are available to the unsold vendor to impeach the fraudulent registration, either to approach the registering authority by quoting Rule 118 of the registration rules, or approach the High Court under Article 226 for the cancellation of the settlement deed. Is there any provision under the Registration Act under what circumstances the registrar can refuse to register a document? Section 1 of Rule 162 of the registration rules contemplates 19 grounds on which the registrar may refuse to register a document. But all of them are trivial in nature. But Rule 55, related with the Section 34, cast upon a duty on the registering authority regard to identify the executant or the person presenting the document for registration. Now there is only one judgment, that is from our Honorable High Court, 2016, 1 CTC, page 673. 2016, 1 CTC, page 673. That is in the Asset Reconstruction Company India Limited. Asset Reconstruction Company India Limited versus Inspector General of Registration. 2016, 1 CTC 673. This is a landmark judgment delivered by the Honorable Justice Mr. M.M. Sundaresh Aski, now he is Supreme Court judge. He gave a judgment. In that case, a registered power of attorney was executed by the owner in favor of his power agent. What are the acts done by the power agent is embodied in the said power of attorney. In the said registered power of attorney, the power agent has not been given any power to alienate or execute sale deed on behalf of the principal. So the registered power does not empower the power agent to execute sale deed on behalf of the principal. But an unregistered power of attorney is there, which empowers the power agent to execute a sale deed on behalf of the principal. Then the power agent prepared a sale deed on behalf of the principal, stating there is a registered power of attorney under which I am fully competent to execute sale deed on behalf of my principal. The registering authority, without perusing, he has not produced the unregistered power of attorney. because in Tamil Nadu, power of attorney has to be registered. So based on the power of registered power of attorney, he has presented a document, executed a sale deed in favor of some X. The document was registered. Then the principal who is affected by the fraudulent registration, straight away he has filed a writ of mandamus for the directing the registrar to cancel the sale. And initially the material of the writ petition is questioned. Senior advocates from both sides were argued in length. Then the Honorable Justice said, a duty is cast upon the registering authority to peruse the document before registering the document. Production and examination of the document is the part of the registering authority duty under Rule 23 of the registration rules. He failed in his duty. There is a violation of procedure. So he cannot take shelter. This is not a solemn act of registration. It is not at all a registration in the eyes of law. When the power of attorney does not empower the power agent to execute a sale on behalf of the principal, the registration of the sale deed by the so-called power agent in favor of third party is illegal, and the sale deed is void and liable to be cancelled straight away by invoking Article 226 of the Constitution of India. Order was passed for the cancellation of the fraudulent sale deed. So, documents which are voidable, necessarily we got to approach the civil court. But a documents which are void on the face of the record, if the document is presented fraudulently by making impersonation, it will not bind the owner. He need not go to the civil court to get his remedy. His option is now open, either to approach the High Court or to the concerned registrar if the particular state government empowers the registering authority to annul or cancel or rescind the document already registered, which are all fraudulent in nature. So these are all the decisions now referred to by me are all greater significance. So in future, please file, do not approach the civil court. It is a cumbersome process. The document is fraudulently registered. Approach the concerned registrar or to file a writ petition. Definitely you will get a favorable remedy. With this, I conclude this session. Though the topic is very small, it involves a lot of legal aspects. And if any question is posted in the chat box, Vikas ji, Vikas, where is Mr. Vikas? Adilakshmi madam, are you hearing me? Madam, unmute. Harita. Chat box open பண்ணிக்கணுமா பார்க்கலாம். Chat box.
One second. நிறைய questions இருக்கு. Can specific performance suit filed without issuing notice to opposite party?
When Mr. Raj posted a question, can specific performance suit filed without issuing notice to opposite party? If without serving any notice, suit for specific performance will be dismissed, because before filing a suit for specific performance, the purchaser has to express his readiness and willingness to purchase the property. Section 16C of the Specific Relief Act is very clear. Unless the purchaser expresses his readiness and willingness to purchase the property, he will not succeed. Not only he has to issue notice, he has to plead that he is always ready and willing to perform this part of contract.
One second. I'm
First of So you, who is posting this question?
Ashok.
Ashok. Answer to Mr. Ashok. If revenue record is treated in favor of your purchaser, you can approach the concerned Tahsildar by producing a document that you gave power only in respect to the particular plat, whereas the sale deed in favor of the purchaser includes the plat which are not mentioned in the power of attorney. And you can also impeach the sale deed by approaching the concerned registrar or to file a writ petition to set aside the sale deed so far as the portion which are not mentioned in the power of attorney is concerned.
Now I can read it. Thank you.
Thank you.
Suggestion made without agreement is valid, which is executable, sir.
Mr.
Yes.
Shahari, he has read this one of Vinod. The message has been read of Vinod, principal executing
You will-
power of attorney.
Well, I answered some questions because you can pass up all the questions to me and I will send my answer.
So Vinod is asking, in 2008, principal executing power of attorney deed in favor of the agent for selling the land belonging to the principal and gave the sale consideration to the principal. However, the agent has fraudulently sold the land in favor of his wife in 2009 itself. What is the remedy for the principal when civil suit or to approach district court?
1 second. So once he gave the sale consideration to the principal, there ends the matter. He can execute sale deed in favor of his wife. It cannot be questioned by the principal. Once the principal, after executing the power of attorney, receives the entire sale consideration, it is open to the power of agent to sell the property in either in favor of his wife or in favor of any third party. That cannot be challenged. If no sale consideration is paid, then the power of the principal remedy is to file a suit for the recovery of the balance, recovery of the sale consideration. He cannot impeach the power of attorney. Suppose the power of attorney is cancelled, thereafter the sale was effected, then the sale can be impeached by the principal. So without cancelling the power of attorney, without sending a notice to the power of attorney intimating the cancellation of the power of attorney, the principal has no right to impeach the sale deed already affected by his power agent.
Now, another question from the YouTube is, it says if the mortgager had deposited the property to some other third person, disposed of the property to the third person, however, the sale deeds title deeds are with the bank, and it is reflected as a mortgage. What is the remedy? It's not on the chat. It's on the YouTube.
YouTube. Yeah, tell me. Please tell me again.
What if the mortgager disposes of a part of the property to some
Madam,
third person?
One second. Please repeat it again.
What if the mortgager disposes of a part of the property to some third person without the knowledge of the bank, though the title deeds are lying with the bank, and it is reflected as a mortgage? What is the property? What is the remedy?
The remedy of the bank is just to ignore the sale, because once mortgage is executed, the bank becomes the security creditor. Without the knowledge and consent of the bank, if the property is sold, it is deemed to be sold subject to the mortgage. The bank has got every right to proceed against the property, even if it is sold by the its borrower. The sale is subject to the mortgage.
Even otherwise, nobody can sell a better title than what he possesses.
Yes. Normally, once mortgage deed is executed, it does not prevent the owner of the property to encumber the same to sell it. He has got every right. But before selling, he must intimate the same to the mortgagee. So this is section 68 and 69 of the Transfer of Property Act. Even if the mortgagor wants to lease out the property, he has to get consent from the mortgagee. But there is no prohibition under law. He can sell it, but the sale deed must contain that the property hereby conveyed is already subject to mortgage, and you have to redeem the mortgage. Then only the sale is valid.
Mr. Ashok, what you had dreaded, he had said that I am the owner of 2 different plots in same khasra. I sold few square yards from.
Answered.
That has been answered.
That has been answered.
So these are the questions. I will just check it out on the YouTube. Yes. If an owner of a property realizes that some third party name is not in the mutation entry, does Limitation Act apply on this, and who should approach? But it's on the YouTube.
Please tell me again.
If the owner of a property realizes that some of the third party names have been mentioned in the mutation, does Limitation Act apply on this, and who should be approached?
Once some third party name is muted in the revenue records, and the moment he came to know from the date of knowledge, he can straight away approach the concerned Tahsildar or revenue divisional officer to remove the entry and seek his remedy. The period of limitation, so far as the cancellation of the illegal entry, Limitation Act does not arise, because this is a wrongful act. For the wrongful act, each and every time it gives cause of action, so there is no time limit. There is no limitation.
The Supreme Court judgment
Section 23 of the Limitation Act, I think so.
Even otherwise, Justice Kuldeep Singh has also held in Supreme Court that fraud vitiates everything.
Yes. Fraud vitiates everything.
Yes, SP.
Fraud is intended to gain illegally.
Yeah. Now this is the last question. What to do if a genuine document is cancelled ex parte by the lower municipal court based on a fraudulent power of attorney?
So not
the second last question.
Yes, yes, yes. Genuine document is cancelled, ex parte. You have to file an application to set aside the ex parte degree or to file an appeal. File an appeal by putting forth your all your defense.
This is if someone has fraudulently given a surety for a loan taken by a company. Company defaults and surety is invoked. What is the remedy for the original owner of the property? Surety for which is given fraudulently.
Repeat it again.
The-
Wait, one second. Yes. If somebody property is given as surety falsely, then it will not bind the original owner of the property and he need not pay any amount to the bank because he is not at all a surety. Somebody has given his property as surety. It will not bind him. It will not bind him. If any action is taken by the bank, straight away he can file a writ petition restraining the bank from proceeding against his property because he is not at all a surety. And his property was given fraudulently as surety. Even he can lodge criminal complaint also.
Yeah. Another question is, it is not with the topic concern. So we are not taking. So thank you everyone for staying connected with us. And friends, tomorrow we will be having a session on the service law part series with Mr. P.S. Rajagopal on dispensing of the inquiry proceedings. What are the trappings? I will thank Ari Lakshmi Lognamurthy and the legal elites, Mr. Shangar Murli, who have been always a pleasure connecting with us on this platform.
One last question.
Yeah,
One last question. One Mr. Chandrasekhar is posted. Vendor received the entire sale consideration and received document, but run away after presenting the document before the sub-registrar and sold the property to others. Then what is the remedy? Once the document is executed by the vendor, before ever registering the same, he left the place. You can compel the registrar for compulsory registration of the document. If the document is subsequently sold, you can file a suit for specific performance suit for specific performance, compelling the vendor to register the document in your favor, and you need not ask for cancellation of the sale deed because the document is subject to your sale.
Yeah.
That's it.
So thank you everyone. Stay safe, stay blessed.
Thank you.
And do stay connected with us tomorrow at 6 p.m. for the part 5 of the service law series by Mr. P.S. Rajagopal. Thank you.
Thank you.